Next case is State of Ohio versus Myles, Trice. The state has waived on this one also, so Mr. Kudici, you will have your full 15 minutes should you wish to take it, and you may proceed whenever you are ready. We've read your briefs and we're ready.
Yes, thank you. Good morning, Your Honors. May it please the Court, I am Richard Kudici. I am court-appointed counsel for Myles Trice. Your Honors, I am not going to reserve any rebuttal time.
I don't think I asked you this time.
No,
Although
but
I did ask the first gentleman. Can I ask you a question just so to clarify something?
yes,
The state, even though they're not here, in their brief suggested that your first two assignments of error were moot because your client has completed the sentence. Do you concede on that or no?
absolutely not.
Thank you.
Absolutely not, and I will address that. And here's the important thing about not reserving any rebuttal time is because the prosecutor has elected not to come here because the prosecutor thinks this is a nothing case. So people might say to me like, Richard, you're appealing a probation violation, really? And that's the most significant thing that I'm here today about, Your Honors. I believe this is a case that is important that this 9th District can pronounce upon. Is there ever a time where a person is not guilty of a probation violation? Are we at a point where simply any type of behavior may trigger a violation? Did this event really rise to the level where the court should have found that my client violated their community control for yelling at a caseworker? Really? To then get a sentence of 270 days, that's significant. So consecutive sentences here were found upon a technical violation. It's critical to evaluate that. So there is an opportunity, and the court then issued consecutive sentences as a result of that. So that naturally is a huge topic because there's no authority for that, for the court to issue consecutive sentences, we argue in this case. So there's a great opportunity in this case, this little case, for this court to expand upon defining what's the burden of proof here. Are we going to talk about substantial evidence? I mean, what is that, substantial evidence? So we have some case law backing on that. Is it a sneeze? Is it preponderance, which is a greater burden? So Myles was on community control here for a couple cases, a CC, carrying concealed weapon case from April of 2017, and aggravated possession of drugs. So Myles is not an angel, but Myles was then placed on community control. He had another situation, and he was placed on community control again. So at this violation hearing, the state produced one witness, and I ask you to take a look at this process. So we have the probation officer as the sole witness for the government. We got nobody there on the scene, and we have the probation officer talking about the record, the report, the hearsay. How far, Your Honors, how far should we go on hearsay on a case like this? Come on, the state prosecutor can't bring in the people that were there. The probation officer talked about some good things. Let's talk about what Myles was doing. He was reporting. He did what he was asked. He was respectful. He did his drug screens. So when he got his new charge in February of 2018, the court saw fit to continue him, but he was placed in CBCF, and that's where all this incident took place. So on a visitation day, the second visit actually that mom comes, mom and Myles are in a meeting. Myles, 2 children, 2 small, one infant who can't walk as yet, and another child are there. Mom brings them in a double stroller that they had been able to come in on the first visit. So this is a case where we're going to blame the parents, Your Honors. We don't usually like to blame the parents. You know, in this case, that's kind of what happened. Mom comes in, she's boisterous, she's yelling. You know, she admits, and even on the witness stand, talks about, you know, her behavior. So remember, when we look at the testimony from the probation officer, and she was not there, this hearsay then becomes the quintessential bases for how the court wants to violate him. So how far should we go with hearsay and credibility?
Can I clarify or ask something to be clarified?
Yes.
Are you limiting what you're saying now to the sufficiency argument? Because I don't know what the record says, I'm relying on the briefs now. Didn't an Oriana person actually testify in the appellant side of the case, defendant appellant side of the case?
Yes, Your Officer. Yes, Your Honor. Officer.
Oh,
Film.
yes.
No, it's funny that I mentioned that witness because her name is Officer Film, and that's the photographer. I thought it was interesting. But she, yes, Your Honor, she did come. But her testimony, when you look at her testimony, what was going on, and what was she envisioning as she was seeing Myles being held back? So this underlying factual basis is critical, and I'm glad you asked that, because is that credible? So here we have mom yelling, we have supposedly Myles is yapping, Myles is aggressive, Myles is this, Myles is that. But isn't it interesting to us who have done this for so long that the visitation still goes on? There's something odd about that, because I'm here to tell you, if all of this was factually true, or the volume of this claim is true, the intensity of it, I submit to you there would not be a visitation there. And that goes on to some of the other factual bases here. They claim after this all goes down, on top of, and this blew my mind, they claim that Myles took a key from a deputy to the gun case. Now, I'm here to tell you, if I did that, or realistically, if Myles did that, he would be charged with not only a crime, but would be taken down on the spot. So the incredibility of that goes to the whole picture that the state is painting here. It's preposterous to even advance that from an eyewitness that wasn't there through hearsay from the probationary report. And that goes to some of the points of credibility. So yes, when you get to that and you talk about manifest weight or the inability for the state to prove their case, then you look at those type of credibility issues. And if you look again at the factual basis for the violation, so mom testified that this was her second visit. In the first visit, everything was good. She could bring a stroller in. The second time, no stroller, no sippy cup, no bottles for the children. So she admits to getting boisterous, and then Myles jumps in to defend mom, and he says, look, what do I have to do to get some attention here? Act out? And that's sort of how he's going, come on, folks, let's calm this down. I mean, mom, calm down. But there's insufficiency to demonstrate any aggression that is sufficient for violation. I think when you look at the standard of abuse of discretion here, and you can reach clearly there's an insufficiency for a community control violation in this instance. The visit was continued, no new charges. He was terminated days later. Let's look at that for 1 second when you look at the fact patterns. If you look at the credibility issues, so why isn't, Myles is aggressive, he's yelling, he's violating the terms, he's stealing a deputy's keys. He's not terminated from the program until a couple days later. So again, these issues are important. Your Honors, let's talk about the standard. I asked you to review the standard. Okay, across the districts we have a little confliction, a little confusion. This court should pronounce a clear standard of review for a revocation hearing for supervision. In this instance, a community control violation. Substantial evidence, that's nothing. Let's have, even at the minimum, a preponderance, where we get a little balance. But what's fair for a revocation? Now, moving into the sentence, this court has the ability to review the sentence. Statutorily, there's only one ability, and that would be to give a sentence of 90 days under the statute. I'll leave that analysis because I think I briefed it sufficiently, but the consecutive sentences, the state itself concedes the court did not make findings relative to consecutive sentences, and that's important. If you contemplate sanction, so what did we got? How long did we get for a sanction? 18 months for yelling at a caseworker. So I know what the state says. They say, look, come on, it's not about that. He got terminated from CDCF. That's not sufficient here. That's not sufficient. Yes, he got terminated, but well, what if CDCF burned down and he could not longer complete the program? Outrageous example. What if the program ended because it could no longer function for whatever reason? Those are all technical violations that they complete. So yes, we need to look at the underlying reason that he was terminated, because the insufficiency and the evidence doesn't support the foundation for his termination, because they didn't stop the visitation, because they didn't arrest him right away, because they waited a few days before they took him back to the jail and terminated him. So let me talk, Your Honors, here about a critical component, because the state argues very vehemently that this case is moot. This case is not moot. There is a substantial reason, and if you look at the two issues that the prosecutor rose, it's not moot because there is a substantial stake that someone like my client, that Myles Trice, has. Now, I'm always to tell my client, don't ever get charged with a federal case. If he does get charged with a federal case, and even in a state case, the very fact that he has a probation violation is going to be an extra point, so his formulaic determination is absolutely going to be determined. So there is a substantial stake. There are collateral consequences that could occur as a result of that. Secondly, there is indeed a remedy. It's meaningful relief. If this court were to vacate this conviction, this community control violation, will most absolutely have an impact upon him. So he does comply with the last two requirements.
What would that impact be if we were to vacate?
If he were to be federally charged?
No, not federally charged. You said if we were to vacate this, it would have an impact on your client. What would that impact?
He would not have the facing of a history in the future if he reoffends. It wouldn't be looked at by either the Common Pleas Court or the United States District Court as a mark against him, and it wouldn't enhance his sentence in terms of sentencing review of the standards that we have. When you were sentencing, Your Honor, we look at the client's, person's history. So when we see a probation violation, we're thinking, wait a minute, he can't do probation, he can't do supervision. So that's the importance of the remedy there. I will leave the details on the manifest weight arguments. I argue to the primary concerns here, the burden of proof, the consecutive sentences, the lack of foundation for that, the reality that he would face a collateral problem if the conviction remains. It's true he didn't successfully complete, but that is, I argue, to not the violation that should be advanced by the prosecutor to succeed in the Court of Common Pleas. We've got to look at, it's important to look at the underlying behavior, because what Myles was saying was, the caseworker really got mad at him, so the caseworker kind of connived. There's no proof of that. But if you look at the underlying factual basis, and if you look at the flow of this case, there's no way that the court can find, in my opinion, a violation. But most importantly, was the sentence, was the sanction fair? Was it punitive? Was it inappropriate under these circumstances with this factual basis? So I know it's curious that I came to argue a probation violation. But Your Honors, I urge you to contemplate the bigger conceptual makeup that I'm advancing here. Because personally, I think it's very important, and I'll conclude by saying this. The reason it's so important, there are so many probation violations, supervision violations that are going on right now, either by parole or by probation. So it is a very timely issue. Secondary, the fact that we're trying to get rid of minimum mandatory sentences, and we're trying to get rid of custodial detention.
With that, your time's up. Good timing.
Thank you.
All right, thank you for your argument. We will take the matter under advisement. We will issue our written decision, mail it to you and to the state.
Thank you, Your Honors, and thank you for your attention on behalf of my client, Myles.